Sri Lanka's most powerful news brand.
Welcome back to Face the Nation. On the final round, my final question is to Mr. Nagananda Kodituaku, attorney at law. Mr. Kodituaku, the Foreign Exchange Act number 12 of 2017. In its preamble, it says that this act has been brought in for several purposes, including to provide for the promotion and regulation of foreign exchange, to vest the responsibility for promoting and regulating foreign exchange in the central bank as the agent of the government. What are the positives you see in the act, as it is important that we need to move forward progressively?
As you said, the preamble says something, may say something, but when you look at it from the citizen's point of view, I have my concerns. The way the minister is given power at the other gentleman's talk. Now, we cannot trust individuals anymore who has violated, those who are responsible for the violation of the trust placed in them, public trust doctrine. Therefore, always the institution has to be empowered, not the individuals. Here you see in this particular act, only the minister in charge of the particular subject is given all this power. Why should that be the case?
But Mr. Kodituaku, the minister cannot act according to his whims and fancies.
But there is no point. When the damage is done, there is no point talking. For example, he, the one who appointed, the Prime Minister is the one who appointed the Governor Central Bank now who is resigned. You know very well, there's a clear violation of public trust doctrine there, because he knew he can't take oath under Schedule B of the Schedule F of the Constitution to respect and honor the Constitution and the rule of law in this country. Can he do that? This man, can he take that oath when he's not a citizen in this country? He can't do that. Now, therefore, so there is no point that, talking these things after the damage is done. The billions of, the rupees of loss incurred. So therefore, there are two major concerns. One, the minister is given all power. Two, there was a deliberate violation of the trust placed in them by the people, the way the bill was introduced. Three, and the all penal sanctions removed altogether. I believe that has to be the case, because in this country, we cannot, our democracy, although we call it a democracy, the rule of law is not respected in this country by everybody. Because now, what I see, our society is such, the integrity is extremely poor. All three organs, their integrity is always at stake. And the people also are the same. Therefore, there may be good intention as well. But the way the bill was introduced, I have my concerns. Because I am only concerned about the rights of the people in this country. I do see, I disagree. There may be certain good intentions, but I believe the way this government came into power, the people elected them for a purpose. That is to deliver what they promise. They who promise, and you can see that in the manifesto as well as the statement made by the President Sirisena in London when he attended this World Anti-Corruption Summit. He said within 100 days we will introduce audit bill. We will introduce the National Audit Act. It was not done. So therefore, the people had their concerns, about the integrity, honesty and credibility of the government. So therefore, my concerns remain there about the honesty of this, honesty on the part of the government.
So you wish to end on a negative, pessimistic note? Or is it realistic note?
Definitely, yes.
All right, thank you very much. Dr. W.A. Vijayawardena, I'd like to move my attention to you. Given all the points that we discussed during the past 1.5 hours, what is your take on the way in which we can move forward as businessmen are watching us right now, citizens, entrepreneurs, economists? What do you have to say about this? Should we not look at it in a positive light?
Sonali, this is actually a way forward measure by the government, because there had been lots of agitations by the business sector in the past about the implementation of the previous Exchange Control Act, where the ministers and the officials of the central bank had penalized unnecessarily people who had been involved in the foreign exchange transactions in the country. So in that respect, what the government has done is it has liberalized the foreign exchange market, and as a result, government is expecting to get the benefits out of this liberalization by way of a free inflow and outflow of foreign exchange into Sri Lanka. And as a result, I might say that it's a good move by the government, and also we have to approve of the government's action, except where they have given these unnecessary powers to a minister who is in charge of the Central Bank of Sri Lanka. Do
you think within the existing framework, Dr. Vijayawardena, that we have sufficient checks and balances on the minister?
No, there are no, because presently, of course, what the ministers are doing, because as we already know, the legislative control over the executive is very weak in Sri Lanka. Judicial control is also very weak, and as a result, the ministers might take this opportunity to penalize their personal and private enemies or political enemies. So therefore, there are no sufficient ground for us to believe that the ministers would implement these provisions with responsibility. And about the issue raised by Chandra a little while ago about this section 22, it's actually a safety clause, because the central bank's monetary board is in charge of the overall financial sector stability. But of course, if there is a very serious threat to Sri Lanka by way of inflow of funds for terrorism activity or outflow of funds endangering the country's balance of payment, then the monetary board will advise the minister that we are facing such a threat, and as a result, the minister has to get the approval of the cabinet to regulate the particular remittances into or out of Sri Lanka Chandra. So it's a safety clause, because we have liberalized the foreign exchange market, but at the same time we have kept with us some powers to act in an emergency. So it doesn't actually reduce the independence of the Central Bank of Sri Lanka, because we have given these powers to the minister, because minister will have to act on with the approval of the cabinet, and also minister has to get the approval of parliament subsequent to issuing these particular orders. So it's actually an emergency like war. In a war situation, you have to go back to the old Second World War type restrictions on foreign exchange. So therefore, I don't think that it reduces the powers of the central bank.
So can we conclude by saying that you're cautiously hopeful about this act?
I am optimistic about the new act, but of course I have always argued that giving powers to a particular minister who is in charge of the central bank is not a good move.
But giving discretionary powers to anyone in Sri Lanka
is not anyone, yes.
All right, thank you very much. My question to Mr. Krishmal Varnasurya, attorney at law, is about an issue that we raised throughout this show about the criminal and civil aspects of offences. I'd like to, before posing the question, Mr. Varnasurya, draw your attention to a part of the judgment on this. The judges, their lordships of the Supreme Court say, we observe that the offences recognised under the Monetary Law Act, the Prevention of Money Laundering Act, the Convention on the Suppression of Terrorist Financing Act or the Bribery Act continues to operate. And any person who has committed an offence with regard to foreign exchange cannot evade getting penalised under the provisions contained in the said acts, even though the bill in hand does not provide for any sanctions for penal offences. Now, this is my question to you. Now, there may be possible money launderers watching our show tonight as well. What is your message to them in case they might be thinking that they could use this act for their benefit?
Two-word answer to all those launderers, Sonali, of our public money is watch out, because the public is watching you and we know who you are, and we will not be afraid to take necessary action against you. When I say we, I mean the judicial arm of government. Yeah, but spot on, Sonali, that's what I said. Let me pause on a positive note. Now, go to the preamble that you read, an act to provide for the promotion and regulation of foreign exchange. So then don't we need to promote and regulate foreign exchange in the Republic? We need to, right? Then let's assume that instead of one minister, right, instead of one minister, we said we replace minister with cabinet. We say, no, nothing shall be done without the approval of the cabinet. No authorized dealer will be authorized without the sanction of the cabinet. Say without minister, we say the whole cabinet, 105 or 110, all of them there. Let's put them. Then do you think that the people will feel more secure? If it's not one minister but the whole cabinet, do you think people will feel more secure? They won't. Why? Because we are looking, I said we need to look at what is now, be warned by what's happening now, which is massive squandering of public monies by everyone that we have placed our public trust on. But look at what ought to be. That's why I say we cannot, no sooner all of us become pessimistic, then we let these goons run riot and continue to play absolute mockery of systems of democracy. So, let's not look at this itself as bad. Now, once again, even if we have given powers to the minister, as the Supreme Court very correctly says, Parliament control, legislative control. The central banks ought to be monitored by the 225 people that we send in. Now, you make sure that the people you send in there, the legislature, are people who are qualified and capable and eminently suited, integrity-wise, ethics-wise, to make sure that robbers are brought to book. Who the money launderer that Sonali was referring to, that they are caught and brought to book, their names are mentioned in Parliament, put down on the Hansard. Then you ensure that out of the 225, those people that you form your executive branch of government, President, Prime Minister and the executive, are people that you can trust will ensure that robbers are brought to book. You follow? That's how we need to look at this. So, legislation in itself is not bad. We need to bring it to a situation, and if both those things don't work, let us have more civic-minded people, like my dear friend Mr. Chandra Jayaratna, more civic-conscious people who will take issues to court. We don't see that the minister has given approval under this act in terms of the act. He has given for arbitrary purposes. He has given, or what he has done is ultra-virus the four corners of the act. Take the fellow to court and ask the Lordship of the Supreme Court or the Lordship of the Court of Appeal to adjudicate on it. That's how we build democracy. Let me finish, Sonali, by repeating what when the American Constitution was drafted all those 300 years ago, what this man was asked, I said this on an earlier show. I forgot, the name doesn't come to it. A lady came up and asked, so doctor, what sort of constitution have you made for us? Another monarchy, because they were under the British. And he said, no madam, we've made a republic if you can keep it. So let us try as people to keep our republic.
All right, thank you very much, Mr. Krishpal Varnasurya. Finally, I move my attention to Mr. Chandra Jayaratna, former chairman of the Ceylon Chamber of Commerce. Mr. Jayaratna, you mentioned the Proceeds of Crime Act, which is a piece of legislation we find in several other jurisdictions. You have gone through this act, especially the UK piece of legislation, and you do think that if Sri Lanka were to bring in such an act, it would be beneficial to Sri Lanka. Could you elaborate on your position with regard to this?
Very definitively yes, but I don't know whether my personal preference is the Australian Act, which I think is the best in my books. Second, the Canadian, and the UK comes third, but I use UK because convenience. But I think before we get into that, just one final note that you have given me. It is, I think, Nadim said, institutions, public institutions strengthening is the best form of democratic governance. Now, to me, this act has taken away that in a great way, and I think even on 22, which Dr. Wijewardena held, was good, with the central bank advising if there is a danger, telling Parliament, ministers agree, Parliament agrees, and they do some act, either to liberalize it or not to liberalize for a short period. But if you do it, the section 22(3), finally it says, Minister may with the approval of Parliament, but no reference to the central bank or the public institution, by an order published in the Gazette, extend from time to time the period of validity. Such extension shall not exceed 12 months. Now this 12 months is, if you take the Irish situation and the Greek situation, these were not stopped for 6 months or 12 months. So if we have learnt anything from those examples, we would not have taken, firstly, the powers of the central bank on extensions to express their opinion, even is not asked. A Parliament and the Cabinet is going to decide on extensions or not an extension, but not the public institution. So to me, two things to be done. Proceeds of Crime Act is an essential feature, and the second is, can we amend this act to restore public institution, which is central bank, to be the main person and not the minister in the administration functioning and the critical judgmental decisions of this act.
All right, thank you
then I
very
will
much.
support it fully.
Thank you, Mr. Chandra Jayaratne, for your thoughts and for being on tonight's show, Face the Nation. I'd also like to thank Dr. W.A. Wijewardena for your time, Mr. Nagananda Kodituaku, Attorney at Law, and Mr. Krishmal Varnasurya, Attorney at Law, for joining us on this discussion where we attempted to disseminate information to the general public, that's you, on the new act with regard to foreign exchange, the Foreign Exchange Act number 12 of 2017, which incidentally repealed the Exchange Control Act number 24 of 1953. Thank you very much for the questions posed to us on our Facebook page, as well as by SMS and email during the course of tonight's discussion. I'd also like to thank Nadim Majid and Faraz Shaukat Ali for their input on tonight's show. I'd like to end this program with one section from the determination on the bill titled Foreign Exchange, where the Lordships of the Supreme Court said, when considering the exercise of statutory power, certain fundamental principles can never be overlooked. The first is that our constitution and system of courts are founded on the rule of law. Secondly, statutory power conferred for public purpose is conferred as if it were upon trust and not absolutely. Words indeed to live by, not just us as citizens, but also those that we elect to power. Take care and good night.